Hello, and welcome to the 21st in series from the webinars from the UK P&I Club. Today, on the topic of the UK Supreme Court verdict on the CMA CGM Libra. My name is Anuj Velankar. I'm your host today. I am based in the Singapore office of UK P&I Club, looking after both loss prevention and claims related issues. Welcome. It's always great to see so many of you coming back to our webinars. So if indeed you're here for the first time, welcome to our club webinars. And if you're coming back, it's great to have you all back here. Just as a bit of housekeeping, you would have been dropped about 5 PDF documents. One of them is certainly the slides which we are dealing with, and others are self-explanatory as well. Please go through them and download them as you require. There is also the Q&A function. Please feel free to communicate. We'll try to get around to as much as we can, but often I find it's hard to get around to them once we are actually starting to discuss the questions, which is why please do register your questions while registering to the webinars, so that we can, the panelists can give them the proper consideration it deserves. Today, for our webinar, actually 1 year back in September 2020, we had a webinar on the same issue, legal implications of passage planning. Back then, the Court of Appeal had ruled on the first instance judgment on whether or not a passage plan, a defective passage plan, could make a vessel unseaworthy. We had discussed that, and once that decision went through, the owners went to the UK Supreme Court. It was a very anticipated judgment. Personally, a bit disappointing one for me. But as we look through it, the judgment of the UK Supreme Court came out earlier in November, so less than a month back, maybe a fortnight back, and it has again upheld the lower court's judgments. So today, actually, we have our work cut out for us. Let's look at 3 aspects. Right? The first aspect, let's look at what actually happened. Let's refresh our memories about what went down with the CMA CGM Libra and what happened in the lower courts. Then let's look at what sort of change happened, or did at all anything change by what the Supreme Court told us. And finally, and this is what I feel is why most of us here today are, is that how is it going to likely impact us, whether we are seafarers on the bridge making and following these passage plans, or owners who now feel compelled to look closer at the passage plans, or cargo and charterers' interests who are not sure what this judgment would mean for their current and future charter party or general average disputes and stuff like that. So all 3 of these aspects is what we will look at. Now, today, I'm very glad that the same panel we had used last year has been able to be constituted again to look at the same issue, which will really give us a good sense of continuity for the people in the audience who were with us and who we are lucky to have again over this year. So the first panelist I'm happy to introduce is Tom Starr. Tom has been, hi Tom, good morning. Tom, you're on mute, but Tom, of course, you might recognize from the last panel as well. Tom has been a seafarer himself, spent time with a ship management company, and then with the law firms before finally moving on to the club. Tom is the regional claims director based in the London office, and certainly incidents like this are the ones which would land up at Tom's desk. So I'm really happy to have you here, Tom. Great to have you here. Also joining us on the panel again is Toby Stevens. Toby is the partner with HFW. Toby heads the marine casualty team for HFW, the law firm in Singapore. And it's great to have Toby from Singapore attending as well. Toby, great to have you back.
Thanks very much, Anuj, and thanks for having me back.
Tom, about the first aspect about what went on and what the lower courts did, I'll leave that with you so that we can start off the day.
Thanks very much. Yeah, morning everyone, and thanks Anuj. I'm going to go through some of the facts in the background just so we remember what happened before I hand over to Toby for his analysis of the Supreme Court judgment. So first slide, please. So we'll just have a look at the facts, just briefly what the claim was and what actionable fault is, because we get, although not so relevant to our analysis of the passage planning, we get a lot of questions on what actionable fault is in general average. We'll have a quick look at the Hague-Visby rules for some context. I'll just briefly say what the High Court and the Court of Appeal judgment said. Most of that will be encompassed in Toby's analysis. We won't spend too much time on it. And just a quick slide on the specifications to set up some of the questions later. Next slide, please. So CMA CGM Libra, she was a 2010 built container ship, 353 meters long, just over 45 meters wide. She had about 6,000 containers on at the time with a draft of 15.15 meters. Now, importantly, at the time, she had a non-approved electronic chart system, and she was reliant on paper charts. She was in that transition period between paper charts and ECDIS, but she did comply with the navigational carriage requirements at that time. Next slide, please. So she was outbound from the port of Xiamen on the 18th of May 2011 in the early hours of the morning, and she was bound for Hong Kong. Prior to departure, the passage plan had been prepared by the second officer in the usual way, and in summary, her track was to stay within the fairway, as you'd expect, leaving buoys 15 to port and 14-1 and 14 to starboard. So on that chartlet, she started in the top left and was bound for the bottom right. By the time she reached buoy 15, she was west of her planned track, if I recall correctly, due to traffic. The master then decided to depart from the planned track, leaving buoy 14-1 to port, and he made an alteration of course to starboard, which you can see roughly in the centre of the chart extract. Upon passing buoy 14-1 to port, the master then briefly attempted to re-enter the fairway, but soon realised that he couldn't do that before buoy 14, and ultimately altered course back to starboard, leaving buoy 14 to port and those various shallows. You can see at the sort of bottom centre of the chart extract. Shortly thereafter, the vessel ran aground. Next slide, please. So the area that the vessel grounded, the depths, the charted depths marked on the chart were about 30 meters. However, there'd been a recent preliminary notice to mariners warning of depths less than those charted in that area. Now, no warning was marked on that part of the chart. It wasn't noted in the passage plan, nor were there any no-go areas. Some of you may know is hatching on the chart showing the danger areas. So the decision, it was said, for the master to depart from the planned track and the fairway in the way that he did was ultimately based on the information that he had in the passage plan and on the chart in front of him. Next slide, please. Just to give it some context, I just wanted to briefly mention the claim and the York Antwerp rules. As I say, not so critical to the issues we're looking at today, but we do get an awful lot of questions about this, so I thought it might be helpful. But when the vessel grounded, the salvage costs were about £9.5 million. The York Antwerp rules were incorporated into the contract of carriage, and owners, after the adjustment, sought a total general average contribution from cargo interests of about $13 million. Now, the vast majority of cargo paid, and about 8%, representing about $800,000 of that, refused to pay, arguing that the incident had been resulted from an actionable fault on the part of the owners, and therefore they weren't liable to pay general average contributions. Now, I'll come to actionable fault shortly, but it's worth mentioning at this stage that cargo interests argued a large number of grounds as to why the vessel might be unseaworthy. They said that the master was incompetent. They said there was a breach of the ILO hours of rest. They said there was issues with the BA chart corrections. They said the crew was over-reliant on a non-ECDIS electronic chart system, a non-approved system. They said they should have had a local chart on board. They said there was a lack of proper bridge team management. They said, slightly tenuously, I think the departure from the fairway amounted to an unauthorised deviation under the contract of carriage. And also the killer blow, as we know, and as we'll talk about later, was the defective passage plan. And they also made some arguments about the burden of proof. As I say, actionable fault, we get a lot of questions about this. What does it mean? This comes from Rule D of the York Antwerp rules. And that says that a party, so here the carrier, the owner, is not prevented from recovering its GA contributions if there's been a fault. However, there's a second limb to that rule, which says, in summary, save for any remedies or defences you may have against that party in respect of that fault. And it's that second limb of Rule D that gives us this actionable fault. So you have fault, which is okay for general average. You have actionable fault, which is not okay for general average contributions. And what the court does to determine if there's an actionable fault, and this is where the issue came from in this, it looks at the underlying relationship between the parties. Here, the contracts of carriage, which incorporated the Hague rules. And what they say is just forget the general average for the moment. If this incident had happened and the cargo had been damaged, so if the Libra had grounded and the cargo had been damaged, who would be paying for that? Now, if the grounding had solely been caused by the master's negligence, that's of course a fault. But if the ship is seaworthy, due diligence has been exercised, owners would be able to rely on the nautical fault defence, navigational defence. And therefore, so that fault wouldn't be actionable, so therefore cargo would still have to pay their general average, and if the cargo had been damaged, they would not be able to claim from the owner. However, the owner can only rely on that exception, as we'll discuss later, if due diligence has been exercised. So if due diligence had not been exercised, and that had caused the grounding, not solely the negligence of the master, that would be a breach of the underlying contract of carriage, and owners would be at fault, and therefore, had the cargo been damaged, owners would then be liable for that damage. So the court just takes that test, puts it into general average, and that's how it determines what an actionable fault is if that underlying contract of carriage has been breached, here with reference to the Hague rules. So there's no, the key takeaway is there's no special standard of seaworthiness in general average. You just look at the underlying contracts of carriage, whether or not there's a defence or whether there's been an actual breach. Next slide, please. So I just thought it'd be helpful to put up the Hague rules, because or the relevant part of the Hague Bisbee rules, because this is what we'll be referring to a lot today. And the key really is Article 3, Rule 1, and that's the requirement to exercise due diligence before and at the beginning of the voyage to, amongst other things, make the vessel seaworthy. Due diligence is a reasonable care and skill standard. It's non-delegable, so always attributed to the owner, and that's a key part we'll talk about later. And if you've complied with that, you then can rely on the defences in Article 4, Rule 2, which includes this the nautical fault defence, the negligent navigation defence we'll be talking about, but also other defences like the fire defence, but obviously not relevant here. Just one key part to remember, that the failure must be causative of the loss. So if there's something that affects seaworthiness with one part of the ship, but actually the incident has involved a loss involving another part of the ship or other equipment, it may well be irrelevant. It's for the cargo interest to make out that case of unseaworthiness, and then the owner has to then prove that it exercised due diligence. And if the unseaworthiness was resulted from the lack of due diligence and there's been damage to the cargo, or here the GA scenario, then the carrier is liable. Next slide, please. So the cargo didn't settle, as we say, and they didn't want to pay the general average contributions. So they went off to the parties went off to the High Court, to the owners trying to enforce their general average contributions. And it got narrowed down really to this passage planning issue. I remember there was all those other areas that they argued, but it really turned on this one in the end. And owners said that passage planning was not an aspect of seaworthiness, it was an aspect of navigation. And whilst the owners had to provide proper means, safety management system, competent crew, etc., make sure there was a system on board for correcting charts, this was really an error of navigation and not an attribute of the ship. And it didn't matter that the passage plan was drawn up before the voyage, it was still an active navigation. And it was actually caused by the failure of the master to return to the fairway in a timely manner, and this was essentially a hydrographic area which is for the authorities. Cargo, as I say, they argued all those other grounds regarding unseaworthiness, and they said that the passage planning, whilst it was navigation, it's really part of due diligence because it's part of the preparation for the voyage, and therefore that nautical defence in Article 4, Rule 2A didn't bite. And it's irrelevant that the passage plan was carried out by the second officer, it was still part of the owner's due diligence. Next slide, please. And I think, as we all know, the High Court agreed with the cargo interests, and they said that yes, the master was negligent, but if I recall correctly, there was a note about the preliminary notice on the back of the chart, but it wasn't properly recorded with hatching or warnings on the chart or in the passage plan. A theme that runs through all of these judgments is that the courts emphasise the importance of passage planning in the context of IMO and SOLAS, the safety of navigation, and emphasised how critically important a proper passage plan was. And it was the plan in the way that it had been constructed caused the master to navigate in the way that he did. Next slide, please. And this was really one of the key summaries from the High Court judgment. The vessel was unseaworthy before the beginning of the voyage due to the passage plan. This caused the grounding, and that it caused the master to navigate the way that he did. Due diligence had not been exercised, and therefore, in our general average context, actionable fault had taken place, and cargo did not have to pay their general average contributions. Next slide, please. So they went off to the Court of Appeal, essentially appealing on two grounds. First, the owners said that the passage plan was an error in navigation, not an attribute of the ship in terms of seaworthiness. It was unseaworthy, and the Court of Appeal disagreed and agreed with cargo interests, saying that an error in navigation can indeed make a vessel unseaworthy, and it was clear that the defective passage plan was an attribute of the ship, and that had led to negligent navigation. On the second ground, the owners said that the passage plan wasn't in the owner's orbit per se, that navigational matters were purely for the crew, and therefore that navigation defence should bite. But the Court of Appeal said no, the owners are responsible for all acts of the master in preparing for that voyage and exercising that due diligence, and that duty was non-delegable, so it made no difference that the master or the second officer had prepared that. And as we'll see from Toby's talk, they went off to the Supreme Court, as I'm sure you all know. Next slide, please. So just before I hand over to Toby, these are the sort of ramifications that have come out from it, and it's been the topic of much debate and our webinars, of course. But after those decisions from the High Court and Court of Appeal, I think most mariners would agree that passage planning is essentially part of navigation, and a carrier under the Hague rules would have a navigation defence, so a nautical fault defence. So has that now changed? But we do know from many other cases that due diligence is non-delegable, and passage planning is performed prior to the commencement of the voyage. So is this any different to the crew maintaining the engine adequately before departure, or carrying out other repairs, or stability calculations and so on? Is it really any different? Which would all form part of due diligence. But at the same time, has that due diligence bar now moved too high? And has the risk shifted? And this was something that came up in the Supreme Court, that traditionally P&I clubs, such as the UK club, would not be responsible for losses arising from negligent navigation. That would fall on cargo underwriters. But with this passage planning judgment, if that is navigation, if that was negligent, has that burden now shifted onto the owners, insurers like the P&I clubs? So with that, next slide, please. And I will hand over to Toby and say thank you very much for now.
Thank you, Tom. Toby, before I let you onto it, I just wanted to take a moment to go over what Tom said. So to the audience, we saw that how the incident happened. Now it has been refreshed to you. You saw the lower court judgment, Justice Tier, and then the Supreme Court coming in. So, Kat, if I could request you to put up our first poll for the day. So I want you to have a look and a think of, because I don't want to, just leave you with my one-sided views on this judgment. But generally, do you think that the judgment was right, or it seems right that action by a second mate before the voyage commences, if that leads to a incident later on, regardless of negligence or not, it might be deemed to make the vessel unseaworthy, right? If you think that the lower courts made the right judgment as it is being appealed to the Supreme Court, please make the appropriate choice. Or if you're still making up your mind and would like to hear what the Supreme Court law lords decided, then naturally the third option is for the undecided people yet. An interesting aspect about seaworthiness, and a lot of interesting questions popping up about the due diligence aspect of the master and the owner, which I look forward to discussing with our panel soon. So thanks for those questions. Keep coming. Kat, let's look at the result. Okay, so I'm not sure we can see the results yet, Kat, but I can assure you, yes. So we have most of the people seem to be decided that, Toby, people seem to be convinced that the lower courts did make the right decision, and a significant portion are willing to leave their faith with what the Supreme Court decides. But I see it's a shift in public opinion over the year. So in a way, do you think the last year has made the market, as they say, more willing to hear the decision that you're going to let us know?
Well, that's a good question. I think it must have done, because I remember very starkly the poll previously was that the court had not got it correct down the line. But maybe people have now come to terms with that decision, and they're more willing to accept it. But I see that still a lot of people are putting their faith in the Supreme Court. So maybe we should see what they've said. Okay. Well, hello everyone, and thanks to Anuj and Tom for having me back to talk about the Supreme Court decision. Can we have the next slide, please, Kat? So Tom's been through the Admiralty Court and the Court of Appeal decision, and we're now on to the Supreme Court. But as Anuj said, let's take a moment, because the two lower decisions were in themselves extremely significant, because they reinforced the importance of the owner's duty to exercise due diligence in respect of seaworthiness at all points of the voyage, but most notably before and at the start of the voyage. However, there was a point of law that the courts decided was significant enough to go up to the Supreme Court. So the owners were granted permission to appeal, which means for the first time in almost 60 years, the legal test of seaworthiness has now been considered by the UK's highest court. And that decision came out just over 10 years after the initial grounding. So that the case is now finally settled through the English legal system. Lord Hamblin, who's an eminent shipping practitioner in his day before he was appointed as a judge, he delivered the judgment with which all of the Supreme Justices agreed. So it is a significant decision by virtue of the highest court in the land being reviewing the whole of the seaworthiness issue and setting out a comprehensive guide to seaworthiness effectively. Next slide, please. So what was determined? Well, the two important decisions that were distilled down, and let's not forget that the Court of Appeal and the Supreme Court are not interested in the facts, whether the judge at the outset got the facts right or wrong. That has been decided. These are points of law. So there were two important questions. Firstly, and the most important, was whether the carrier's obligation under the Hague Rules is subject to a category-based distinction between the seaworthiness on the one hand, which concerns the attributes and the characteristics of the ship itself, and on the other hand, the navigation and management of the vessel, which concerns how the crew navigates and operates the ship using those attributes and the equipment on board. And then the second question related to the owner's obligation to exercise due diligence, and in particular, at what point the owner can be said to have discharged that obligation. Now, quite interestingly, the Supreme Court went to great lengths to look at the history and development of the Hague Rules to ensure that their interpretation had broader reach than just the UK legal system, because it recognised that the international conventions like Hague Rules should be interpreted by broad and general principles of construction rather than any narrower domestic law principles. And in fact, they quoted an earlier judgment earlier this year in the ever smart collision with Alexandra 1 that was also heard by the Supreme Court, and that was looking at the collision regulations. But the court agreed that when you're looking at conventions, you need to take a much broader approach. So what they're thinking is, of course, it's got broader appeal. Everyone is looking at the judgment far and wide, and that, of course, is what they should do. Now, in looking at the history, they went through the discussions, the initial conferences that were discussing the Hague Rules, and dozens and dozens of cases in the UK, with Privy Council in the US and in other jurisdictions. So what they took from that was what the global feeling was on the interpretation of seaworthiness, rather than just a narrower UK perspective. Next slide, please. So, issue one, seaworthiness. So, in respect to that first issue put to the court, the owners argued that there was a distinct difference between seaworthiness on the one hand and the navigation and management of the vessel on the other hand. And what they argued is that the Hague Rules draw a clear distinction between the navigable state of the vessel, so i.e. the attributes of that vessel, and the navigation and management by the crew. So they're trying to make that distinction. And so they argued that, firstly, passage planning is navigating, albeit carried out prior to the commencement of the voyage. And secondly, a defective passage plan in itself doesn't make a ship unseaworthy. And this is because it's a navigational decision and it's not an attribute of the ship. So a passage plan, what they argued was it's a set of navigational decisions that have been recorded and therefore not an attribute of the ship itself. And then finally, a defective passage plan, therefore, cannot render, for example, the underlying chart defective. So in looking at the Hague Rules and all of the cases that the court reviewed on seaworthiness, the court rejected the argument that seaworthiness was solely concerned with the attributes of the vessel. Rejected that completely. Next slide, please. And instead, they found that although the attributes of the vessel could show that the vessel was unseaworthy, if you had defective charts or whatever, but any distinction between the attributes of the ship and the negligent navigation was flawed because there was no attribute threshold in law. So they dismissed the owner's arguments on that. And in fact, they went a bit further because they said that unseaworthiness can be caused by negligent navigation and poor management. So those are the Article 4 Rule 2 exceptions. So those can be exceptions to unseaworthiness, but here what the court is saying is that actually they can cause the unseaworthiness. So meaning that seaworthiness and navigation are therefore not mutually exclusive. They can be one and the same. And it didn't matter in this case that negligent navigation was in fact the unseaworthiness. They did, however, accept that passage plan is a matter of navigation, and they also accepted that a failure to mark uncharted depths on the passage plan and the underlying working chart would amount to an act, neglect, default navigation of the ship within the meaning of Article 4, Rule 2. However, those exceptions cannot be relied upon where the owners have failed to make the ship seaworthy in the first instance. And for that, they looked at a 1959 Privy Council case called Maxine Footwear versus Canadian Government Merchant Marine. And quoting from that judgment, it said, Article 3, Rule 1 is an overriding obligation. If it is not complied with, the immunities of Article 4 cannot be relied upon. So they just dismissed that completely. The error in navigation defence did not stack up if you do not fulfil your obligation to exercise due diligence to make the ship seaworthy at the commencement of the voyage. Just as an aside, there was quite an interesting discussion about remediable defects, and they looked at a US case in that regard called the Aristo, where the charts were not up to date, but the court there found that the means and the time were available to the crew on board to correct the charts, bring them up to date before they were going to be used. So in that case, there was a bit of a distinction, but in the Libra, the Supreme Court said, they rejected the idea that the passage plan could have been rectified before use, because of course it was going to be used for navigating from the berth, and once it had been completed, yes, in theory it might have been able to be corrected, but the reality was that once it had been signed off by the master, it was not going to be touched again until it was used for navigation. So that's just a bit of an aside on rectifiable defects. Next slide, please, Kat. So one of the other, or the next logical step in looking at seaworthiness was the prudent owner test, and the Supreme Court confirmed that the prudent owner test is still good law. And essentially that says, or the question is, would a prudent owner have required the defect to have been made good before sending the ship to sea had he known of it? And first instance, the judge found that had the owner in this case known of the defect in the passage plan, then yes, he would have required it to be rectified. And there was quite a bit of discussion of this, particularly as there's a case called the Aqua Charm in 1980, which illustrated that the prudent owner test is not universal. So it's not used in absolutely every case. In that particular case, there was an overloading, but it was to do with whether the vessel could get through the Panama Canal, Suez Canal. But anyway, the court in that case found that it was not such a dramatic element that what they found. Sorry, it was on the borderline of unseaworthiness. So the Supreme Court in the Libra decision distinguished it and said that the prudent owner test had stood the test of time, and Lord Hamblin had said in many cases it was a helpful and appropriate test to apply, largely because it was well suited to adapt to differing and changing standards. And that, of course, is going to be quite important for the implications of this judgment going forward, because all of these standards of seaworthiness are relative to the vessel, the cargo, the contemplated voyage, and therefore standards may well rise. In fact, they're likely to rise to reflect improvements in, and he gave the examples of shipbuilding equipment on board and, of course, navigation. It is another, for me, another example where the UK case law is adaptable. They take the principles and you can adapt them to the changing circumstances, and perhaps that will come up in the discussion. But if we can have the next slide, please, Kat, we'll move on to the second element that had to be decided by the Supreme Court, and that was due diligence. And in particular, what did the owner have to show to prove that he had exercised due diligence before or at the commencement of the voyage. And so for this element, the owners argued that so long as the carrier has properly equipped the vessel so as to be navigated safely, such as providing competent, well-trained crew, current charts, having safe systems on board, providing crews with those tools, the attributes, if you like, of the vessel, then the crew's failure to safely navigate the vessel is not a lack of due diligence on their part. But again, the court rejected that argument, and what they said is the carrier is liable for a failure to exercise due diligence by the master and deck officers of the vessel when preparing a passage plan. So they said no, that doesn't work. In effect, it reinforced the position that this is a non-delegable duty, and what they said was because all of the acts of the master and crew in preparing the vessel for the voyage are performed qua carrier, so it means in the capacity of the carrier. In the same way that if there were a whole host of previous judgments that were discussed, analysed in minute detail, and lots of them all looking at how the owners would delegate repairs or other elements of preparation to sail to specialists. However, in those cases, the court invariably found that it's a non-delegable duty, and the owners were still held responsible, even where that failure to exercise due diligence could not easily have been spotted prior to the vessel sailing. And one of the old cases on that is called the Muncaster Castle. I won't go through that, but it's summarised in the Supreme Court judgment. So very much finding for in particular the judge of first instance and the judgment of the Court of Appeal. So the Supreme Court dismissed the appeal by the owners. Next slide, please. So if we summarise, really, the Supreme Court judgment confirmed the decisions below, as we now know. They said there's no category-based distinction between navigability on the one hand and navigating on the other hand. Article 4, Rule 2 exceptions cannot be relied upon if the carrier is in breach of Article 3, Rule 1, which is an overriding obligation. And if unseaworthy, there's no difference if navigation is the cause of that unseaworthiness. Unseaworthiness is not subject to any attribute threshold. That doesn't exist in law. And a prudent owner test is still applicable, save in exceptional cases where it's on the borderline of seaworthiness. Next slide, please. So continuing the summary, if a defect is remediable, it may not be unseaworthiness, but again, that's quite a high test to overcome. A vessel is likely to be defective if she has a defective passage plan, given it's of essential importance. Sorry, I probably should say unseaworthy. Due diligence to make the ship seaworthy must be exercised regardless of who performs it, master, crew, shoreside maintenance, whoever it might be. And finally, the carrier's obligation is not limited to providing a proper system for preparing a passage plan. It goes much further than that. So I think that is the run through the judgment, and perhaps I can hand back now to Anuj.
Thanks, thanks, Toby. A great talk. And I'm been really very interesting questions popping up. We are slightly behind time, so let's jump into the Q&A, and I'm really looking at exploring these threads further. So, I mean, Tom, giving Toby a breather, nothing seems to have changed, right? Because the first question people are asking is, you know, the passage plan is wrong, and you're all talking about owners' due diligence and all. So, is the master firm still firmly in control of the passage plan, and is it on his or her shoulders that the responsibility lies?
Yeah, absolutely. And I think we have to be just careful to talk about which context we're speaking about here. We're talking here about a cargo claim under a contracted carriage. We're not necessarily talking about port state control requirements or flag state requirements or so on and so forth. So the master and the crew are still, yes, responsible for the navigation of the ship, the passage planning, and I don't think the master's responsibility has changed in that sense. What we're saying here, in the context of a claim under a contracted carriage, what's the master, or whether that be, and I saw one of the questions pop up, whether that be an ISM ship manager, a technician, the second mate, the chief engineer, if they're preparing that vessel for that voyage, and subject to some of the limits that Toby touched on as to what would and wouldn't be render a ship unseaworthy, that's attributable to the owner in what they do in that Hague Visby contracted carriage setting. So it's just that the owner can't delegate it. It can have the best subcontractors, agents, crew in the world, and experts in every possible aspect of shipboard life, but anything that they do is still attributable to them as the carrier under those contracts of carriage.
Toby, we have understood now that, okay, there is unseaworthiness and there is some due diligence. So the question which popped up, an interesting one, was that do owners get some consideration for the efforts made? So, for example, okay, the passage plan was bad, but I tried to do nav audits, I tried to send my superintendent, we are trying to look at the passage plans, second mate is sending them to the office. Do we get bonus points for trying?
I'm afraid not, Anuj. If the plan is defective, then there are no bonus points. It's an absolute duty and it's a non-delegable duty. So if it is defective, such as it then causes loss or damage, then I'm afraid the owners are going to be liable.
The owners did try a similar argument to that in the cases as well. They said, you know, that well, you know, we've got this system on board ISM, we've got a competent crew, we've done all this, and you know, that's fine, and that is part of it, an important part of it. But it didn't mean that they could then delegate that responsibility to the master once they'd set that up. He was still part of it in terms of their due diligence.
There was no argument that the owners had provided the correct charts, the notice to mariners. They'd got all of the equipment that the crew needed. It was just an error in the execution of the passage plan. But because that was formed part of the preparation for the vessel to sail, it then was an element of seaworthiness rather than navigation.
I understand, Toby, but herein lies the problem. You see, you of course deal with ships regularly, and every sailor on board knows there are many things wrong with the ship. In fact, the last question down the line, Prashant, which asked, is the same thing. There are actually known defects. So there are like a defect list under the ISM code which is made. A lot of people in the audience are asking this. So, I mean, if that defect then causes a problem in the voyage, does that mean that a vessel is unseaworthy again, and how does it work?
Well, that's again where the prudent owner test is useful. Now, of course, the prudent owner is looking at the average standards and query what those are. But in the maritime sector, there are a lot of standards and guidelines, and I think many of us know, many with more technical knowledge can look at a ship and know whether it's seaworthy or unseaworthy, or whether a particular attribute of the vessel is one which needs to be rectified before the ship is put to sea. So having a list of defects is absolutely commonplace, and the court is not saying that a ship needs to be perfect before she puts to sea, but there needs to be a fundamental level of seaworthiness before that occurs. So if the owners had known about the passage plan being defective, would they wanted it to have been rectified? Well, and the difficulty is there that in many occasions, you're looking at the situation after there has been a loss. So of course the owner would say, well, yeah, of course I would want the passage plan to have been rectified, or whatever it was. But there is a reasonableness element to this due diligence, or the prudent owner test. So that's the balance.
Thanks, Toby. The next slide, Kat. So, Tom, if I could direct you to the next set of questions. Here we are again in the Q&A live. Also, I'm getting this feeling. A passage plan is meant to be fluid, right? So as the situations develop, even the traffic while we are navigating the vessel, is it making a passage plan rigid? What aspects of passage plan were attacked in this judgment?
I think we all know from being a sea that you can never always stay on your planned track, and you have to deviate on it. And I think it would depend on the facts. But think of it in the context of the CMA CGM Libra. The master, for whatever reason, decided to deviate from that planned track. Now, would he have deviated where he did had he known that the depths in that area were below that was indicated on the chart that would have caused his vessel danger? Probably not. You would have had to have done something different. So if the court said it in the case that the passage plan and the way that it was formed and the way that the chart was drawn up caused the incident. So yes, the master was negligent, but that was caused by the passage plan in front of him. So I think it would depend. So if a ship deviates from a track and clearly puts itself into a navigational danger, which should have been marked on the chart, should have formed the passage plan, then yes, we may have an issue. Otherwise, if all things being equal, if the passage plan is properly formed and there's a deviation which causes a loss, that may just then be crew negligence, negligent navigation, and the issues in the CMA CGM Libra wouldn't have come to light. So I think it depends on the circumstances, but just because somebody has to deviate from a passage plan does not necessarily mean the ship is unseaworthy. It doesn't necessarily mean that deviation is negligent, and it may or may not, depending on the circumstances of that, have implications as to what due diligence was exercised before the beginning of the voyage.
Interesting, Tom. Toby, in a similar vein, Vincent at the bottom asks an interesting question. Before leaving port, I don't know where I'm going. So charterer asked me to head out to sea, and let us say after 12 hours, he says proceed to Singapore. So now I'm landing my passage, and there I miss out on marking a TNP notice. So do you think the facts would match the CMA CGM Libra?
Well, I think there's a distinction there, because it is after the commencement of the voyage. So, and that is very critical distinction historically, and now it's been confirmed by the Supreme Court. So, if there is an amendment made due to charterer's orders or whatever it might be after the ship sails, and that is the point where a defect creeps in, then I think that there is there's a very good argument. In fact, my belief that that is not unseaworthiness at all, unless the owners have failed to put the correct charts or give access to the relevant pilot book or whatever it might be. Because if it's purely on the on board, then that's navigation, and the Supreme Court have accepted that passage planning is an element of navigation. So the timing is critical here.
Okay, perfect. Thanks. Next slide, Kat. So now moving on to the owner's liability. This is something which has been popping up a lot of questions and comments. By the way, I must thank the audience. It's a very committed audience with very strong views on the subject, and I am unfortunately not able to direct all your questions, but I see this a lot. We are talking about now that the passage plans are being monitored by the shore. So people are talking about the ship staff sending the passage plan ashore for approval or monitoring during the voyage. Certainly, our last webinar was on technology in shipping, and we discussed how the shore can monitor the deviations from the voyage as well. So if the ship deviates from the cross-track error, or there is a large alteration of course and our rate of turn exceeds it, alarms go to the office. So is this increasing? Do you think there is a mention or a indication in the Supreme Court or Court of Appeal judgment which guides the owners to do something like this?
Well, in having that duty to exercise due diligence, the owners have a number of options now, because technology gives them the ability to see what is happening in real time, but also to review and check passage plans. I mean, that is something for the individual owners to think about, because everyone knows the crew is under pressure, particularly in port, particularly in something like the container trade. So that obviously is something that could help the crew. What is interesting to me is what the next step is, because the Supreme Court has said the law is adaptable to the circumstances and the changing circumstances, the changing technology. So it isn't there yet, but is it conceivable that in a number of years, particularly with the advent of a greater degree of autonomy, both in component parts and reduced crew interaction, more of that decision making being taken shoreside, will there be a continuing obligation to make the ship seaworthy throughout the voyage because of that connectivity? It's not there yet, but it's something to think about for the future. Right now, as we said before, the critical timing is the commencement of the voyage, and so manager's approval, yes, is also common, but of course, if a defect creeps in and is not spotted by the office, then again, you're still going to have the same problem. The vessel is not seaworthy.
I think shore approval comes with its own challenges as well. It may well be appropriate for certain trades, and as Toby said, it may well actually be a benefit in certain trades. But I think particularly dealing with casualties, we've all seen situations where the masters have been very reluctant to make certain decisions because they feel they have to go through shore staff on every aspect of the decision making process, certainly after the casualty, but sometimes in the lead up to it. So the other risk, again, depends on the ship, the trade and the company, that could foster a lack of confidence on board or a lack of autonomy, and that again could come with its own problems in delaying certain actions, where obviously in years gone by there was very little contact with the shore, so the crew and the master were forced to make these decisions based on their own judgment. Again, advantages and disadvantages with that, with no connectivity with the shore, but it has to be weighed up against those other risks that it might be, the unintended consequences of having too much involvement with day-to-day shipboard activities from ashore, where the crew could have authority and judgment to do that.
I agree, Tom, and we've all seen situations. I think no matter what business we're in and what your chain of authority is, but if you insist on reviewing everything that your subordinates do, then I think there's an element of complacency that can creep in, as you were saying or alluding to, Tom. And you can envisage a passage plan being rushed out and sending it to the office, thinking it'll come back correct if it needs to be. So that is an element where I think that errors could creep in. If you don't give proper autonomy to people, but that's just a human factor.
Because we have such strong opinions on this particular subject from our audience, I wanted to give this question to the audience itself. Kat, I think, can we put up that second poll? So, you heard the panel's views on whether it is required or whether it is desirable, the inherent dangers themselves of too much monitoring of let us say a micromanagement with something like a passage plan. Certainly from my communication with the industry, for the people in the audience who were with us last webinar as well, this is a growing trend. It seems to be there whether we like it or not, but yet I think we are entitled to an opinion whether we are happy that it is there or not. So we have a substantial population in the audience from who are sailing as well, and of course from the office people. So let's look at the poll. Well, thank you for the poll. We're pretty evenly matched. Probably before we started, we also should have taken a poll of sailing and the shore audience. I
was going to say it'd be interesting to see the breakdown of the voters on the respective sides of that. Yeah,
very interesting. But I think the industry certainly seems to be evenly divided, let's put it this way, because as I was seeing the polling, it was going up and down on either side. But certainly, looks even. Thank you, Kat. One aspect I just wanted to drag further with you, Toby, was you mentioned there might be a possibility that we are looking at seaworthiness throughout the voyage and at beginning of voyage. I understand there are different seaworthiness requirements for voyage charter and time charter, right? So time charter is for throughout the voyage. So can the time charterers use this judgment to push? I'm grappling for straws. This is not really an audience member question, but there is an obligation on owners for seaworthiness throughout the voyage under the time charter, right?
Well, it's through the voyage. so the seaworthiness obligation in this context. So what we're looking is Hague rules. So we're looking at the obligations to the cargo in particular, rather than to the charterers. Okay. And yeah, there are aspects of this judgment that are going to be applicable to thoughts of provision of a seaworthy ship and a charter party, but this is very much looking at cargo, Hague rules, and whether there is actionable fault, as Tom was talking about. So it's a slightly different test, although I recognise that there are crossovers there.
It also depends on the charter party, because a lot of the ones we see have a clause paramount which incorporates the Hague-Visby rules, even in time charters. So it might be before each and every voyage under that time charter. Some of the shell time forms have ongoing obligations to maintenance. And some of them have, if it's not qualified, there's an absolute obligation of seaworthiness. So it does vary. It does vary as to where it would actually bite.
Thanks. Kat, next one, I think, because that actually is on the charter liability issues. So another question which is coming up is often is what Nico asks in the middle there. What they are asking is, if it is the owner's responsibility to have a proper passage plan to maintain seaworthiness, why doesn't the owner just give the passage plan to the cargo interests and ask them to sign off on it? So then, even if it is incorrect, the cargo owners can't come back and use this as an excuse.
I think there's a few things there. Firstly, even if another party was to sign off on it, it would still be attributable to the owner because it's non-delegable. We see charterers, and I think someone's mentioned the BIMCO risk clause, and we see vetting and various inspections. But again, it's all non-delegable. But I think first and foremost, the charter would be very, very reluctant to give any kind of approval, even if it could, or share any of that responsibility or liability for that passage plan. Some charterers do operate ships and have sophisticated technical departments. Others won't be in the position to verify that. But I think generally it's still going to be attributable to the owner. And secondly, I think a cargo interest or a charterer will be firmly wish to leave matters of navigation to the owner, and indeed many contracts of carriage specifically say that.
Bobby, do you think the owners, in this same context, do you think like owners and charterers relations are going to be changing? Any new clauses? Because generally when there is these big rulings, sometimes people again look at their charter parties to see if they might put something in or remove something. Any change in?
A good question, Anush. And I can't immediately see what is likely to change, because the obligation on the carrier doesn't change. Let's again remember that this is largely for the benefit of cargo interests. So their relationship with the carrier will be by virtue of the bill of lading. Now, there may be a charter chain in there. I don't know. I can't immediately see how even if owners came up with a clause that it would be immediately acceptable, because this is now what the Supreme Court has found. Why would a charterer or a cargo owner agree to derivate or deviate from the Hague rules that give them the protections? I don't see it in this particular case, but I could be wrong.
Thanks. Can we move on, Kat, to the next slide? So, again, on the procedures, I don't want to go inside too deep, but a few interesting questions which were asked was that, quite often there are no clear depths to the port. There are no charts to the port, or the vessel may not really have a chart when she leaves. So, for example, I gave you a example that vessel is out and asked to proceed to Singapore. Vessel may not have Singaporean charts at that time. Now it's slightly less likely with the ECDIS coming in, but the charts may not be of good quality as such, with the depths not properly charted themselves by the hydrographic organization. So when we are looking at these aspects, and then our vessel is asked to plot a passage through it, do you think it is going to affect what are the things that pop up? Toby, for you.
So, yeah, look, just going back to the being asked to deviate or take on new orders. Again, we could sort of come back to the twofold test, really. One is, was it at the commencement of the voyage? But I mean, any self-respecting navigational officer or owner would not allow, or should not allow, I would say, a vessel to proceed to a port where they do not have the adequate charts to navigate. And clearly that's something that ought to be rectified prior to proceeding. Now, as a matter of law, it is not at the commencement of the voyage, but I mean, there are a host of other issues that will undoubtedly come up if that's what the owners ordered the crew to do.
Please do also, there is this confusion I'm seeing in the threads about what master's responsibility and owner's due diligence. From my understanding of what we have spoken now, it is like there is a responsibility of the master to certain parties, but if there is an accident, so let us talk about the CMA CGM Libra case. The master deviated, so his responsibility was to the safe navigation of the vessel, but the deviation happened and there was a grounding, so the owner is not doing due diligence. So what is the connection between the ship staff's responsibility and owner's due diligence? Does the ship staff, whenever they are not being fully responsible, automatically land on the owner's shoulder as well?
Well, yes, and again, just sort of reading from the judgment, saying in essence it's a non-delegable duty, but so the owner has the duty to exercise due diligence to make the ship seaworthy. In practice, of course, the crew will put together the passage plan, as happened in the Libra. But the point is that when they do that at the commencement of the voyage, they are not acting as navigational officers in isolation. They are doing it what's called qua carrier, so in the capacity of the carrier. Qua being the Latin, but yeah. So it's not a particularly easy distinction to make, and clearly there is overlap when it comes to elements of navigation. But again, we go back to the element that it's all of the matters that are carried out in the name of the owner, effectively to make the ship ready to sail.
And that could be technicians, it could be the engine room crew, and there are a lot of judgments in not just English jurisdiction, but in all the major maritime jurisdictions, and some of those that the Supreme Court touched on, where things that have been done or not done, as the case may be, by the crew before the voyage, securing fittings, maintaining elements, stability, you name it. There's a whole body of case law there, albeit very fact specific, about where qualified technicians, consultants, crew have done things in preparation of the voyage, where that has then caused the loss. And I think the causation point is very important to remember. Caused the loss, and that's because it was done before at the beginning of the voyage. It's attributable to the owner. The owner can't get away from that. As I said, if it delegates to a ship manager and so on. And I guess the ultimate goal of this was that to avoid irresponsible ship operators or owners saying, well, you know, that's the captain's fault, it's not my fault. I'll have my commercial interest, please. And relieve itself of those sort of responsibilities. But of course, I'm not suggesting that that's what people are trying to achieve. That's just the way it has worked, and the owner can't get away from that. We spoke also about defects, minor defects in that record in the ISM defect log, or technical defects, or whatever system they use. Faulty emergency light, temporary fault in emergency lighting is going to have no bearing on a grounding. It's got to be causative. So, we've seen situations where there might be accidentally a faulty piece or expired piece of safety equipment, but if that has no relevance to the cause of the incident or the grounding, then yes, in another day that would be the issue for unseaworthiness, that faulty piece of equipment, but it's just not relevant to the incident that's taken place. So the standard is still quite high there, if you think of it, at least in the causation sense. All those planets have got to align. And if you look at the CMA CGM Libra and all the things that happened to fall into place and all the arguments that cargo made, and it was just that one that joined all the dots, and it was the passage plan grounding in that place marked on that chart.
Kat, can we move on? I think close to wrapping up itself. While we wind down, we've got a couple of interesting questions. So the first one, John, which is asking is that, it is important that the master has the final word on the navigation. And, currently, when we are looking at the advances in connectivity and data, they will certainly look at more checks. I know we spoke about this a little bit, but your parting thoughts on this issue, Tom?
I don't think it's maybe as groundbreaking as some people have feared. As I say, there's a huge body of case law there where all manner of defects have rendered a vessel unseaworthy. The unseaworthiness has caused a loss, and it's been traced back to a lack of due diligence. And it's well established that an uncorrected chart, for example, again, if causative, the incident would render the vessel unseaworthy and demonstrate a lack of due diligence. So I think, in port state control, for example, when we're getting inspections, slightly different context, but I think a lot of people have considered a long time that a passage plan is one of the documents that may well be checked along with the ship certificates. And if it's not adequate or the chart correction not up to date, then you're going to have a defect with your port state control inspector. And it's not too difficult to put that situation in the context of what we're talking about here with due diligence and seaworthiness, and seeing the slightly different effects in a different context. But I don't think it's a huge step. So I think for me, this is really more confirmed what we suspected. Again, that some of the elements that Toby pointed out that the Supreme Court have gone into are helpful and have maybe changed our perspective on a few things. But I think, let's not forget that cargo, they argued, was it 7 or 10 grounds. It happened to be that chart, that passage plan, that part of the voyage, that moment where the master decided to deviate from the fairway. If that passage plan had been fine, but there had been an uncorrected chart for the arrival port, we wouldn't be talking about this because it wouldn't have been causative. So I do think that it's really confirmed what we know. It's given us some more guidance. It's given us, it's highlighted or reminded us the importance of passage planning. But I don't think it has dramatically changed the landscape. I do think we'll probably see more attempts to pick faults in a passage plan in the maritime claims context. I think it'll be it'll encourage people to try those arguments when there's been a grounding or so on. But again, they've still got a relatively high bar to cross to actually establish that causation, the link between the defect and the lack of due diligence and the cause of the casualty.
Very interesting, Tom. Thanks a lot. Toby, sorry, go ahead.
Yeah, I agree with all of that. I think for me, it shows a logical progression as technology, regulation, guidelines advance. It's adapting to those changes in technology and regulation. And whilst it's uncomfortable for some people, I think it's not unusual. It's not particularly a surprise. Even in the 10 years since the grounding, I think people have recognised or have even more recognition for the importance of passage planning. I mean, when I not long after I first joined HFW, there was a case that we were handling for called the Torepo, which again looked at passage planning, and that's referred to in the Supreme Court judgment. In that case, the passage plan was found not to be defective, and the judge David Steele in that case said even if it was defective, the owners had provided all of the underlying documents on board, so they were not to be criticised. So there is a progression. There is that change now, but that was nearly 20 years ago, and standards have improved dramatically even in that period of time. So I think this is just the courts keeping pace with standards at sea.
I see what you mean, Toby, but isn't there a converse danger I learned a new word recently called penumbra. Like the light, there is a bright and a dark, and in between there is this gray. And I feel that higher the code goes, the larger the penumbra becomes. So, if it was just Justice Steer talking about passage plan, everybody would just talk about passage plan. But now when the Supreme Court talks that passage plan makes it unseaworthy, like at the bottom of the page, you have Hubert, Nisha, Ravi. Tomorrow, there is a bigger chance that the third mate didn't sleep. So that made the vessel, and then obviously third mate didn't sleep in port. So that was before the departure. So fatigue becomes a issue. You could have mental health. You could have various other things which till now, let's say, have been under the woodwork, which suddenly gain more importance. And I feel that with somebody of the position of a Supreme Court making a decision, these things have a higher probability of creeping out.
I agree with you, actually, Anuja. I think it is there. I don't think it's as dramatic as all that, but I think that there is a logical progression. And yes, passage planning was the focus of the Libra, but the concepts that are in place now are as broad as they were before. Unseaworthiness can be anything. I think that there is a focus, but again, Tom's absolutely right. This isn't a case in isolation. This is the case now. This is the one that's in focus now. But if you read the judgment, there are dozens and dozens of cases, all dealing with unseaworthiness, and you can see there. This is not a particularly remarkable movement. There is a bit of movement. There is advancement, but it's not a quantum leap. It's I think a natural progression.
Thank you to both Tom and Toby. It's been a very fast 1.5 hours, and thank you for taking out your time and coming back. Coincidentally, you two are the only panelists who have come back on our panel, and so at least people do return back to the panel. In a way, I'm glad that it is not as feared as it was. So thank you so much to both of you. It was great having both of you here.
Pleasure.
Yeah, absolute pleasure. Thanks very much.
Kat, next slide. Perfect. So to all the audience as well, I mean, our sincere thanks. We actually have a lot of audience attendees and friends in the audience today, which I recognize from who have been there, you know, not only during the last time we spoke on this topic in September last year, but through our various webinars. I recognize a teacher of mine, you know, who taught me in college. It's brilliant to have all of you here. I'm really grateful for the excellent support that all of you have given us over these 21 months. This, of course, is the last webinar of the year. So I do wish all of you a very pleasant, happy, healthy end of the year festivities, and naturally the hope that our coming year is going to be better than the one which we are packing. Today we couldn't start with our traditional loss prevention video. So please do, after our goodbyes, if you have time, stick for our next a small 4-minute video. You all know I love our lessons learned videos. This is on enclosed spaces, but with a slight twist, because the engine staff working on refrigerated machinery, not something which we usually think of being a risk. And it just highlights that risks can lie at various unforeseen places. I love these videos simply because they are 3-minute, 4-minute videos. You can use it as a job safety analysis video, or spend a full half an hour safety meeting doing a reflective learning with your crew. So hope you do stay. But all of this is available on our website. I forgot to give a shout out to our Ask an Expert. You know, we spoke about the new procedures, lack of ENC. All of those aspects have been dealt with in our latest Ask an Expert with Captain Vincent Fernandez. You have the drop down with you as an attachment, and it's a relatively short 25-minute talk with him about what, you know, firstly, whether these incidents can happen on an ECDIS, because this was our paper chart, and now how can we avoid these incidents from happening, and on an ECDIS, what are the key steps to make sure that your passage plan is safe and accurate. So please do have a look at it. As I said, your drop-down attachments would have that. Thank you once again. Please drop your feedback on what topic you would like, what you liked about us, what you thought didn't go as well, and hope to see you again next year. Thank you to all of you. Thank you to the panel.